Hello, good evening. It's Monday, the 28th of July, and we were just hoping that Karis could join us, but I think there's some technical problems preventing her. But hopefully, she'll be able to join us during the time we're on. But I'm very pleased to have Mike and Shannon here. Hi, guys. Although I have said hello before we started. Um, so I've got a few things to talk about tonight, I'm pleased to say. And I have done some preparation. Um, and I will try and keep it short. If anyone's got, I don't get as many comments as Mike's videos, but I'll just open my browser up so I can see the comments easily. In fact, just in case. So we'll try and answer them. And while I'm uh, reaching around for that, just to remind people, please keep it anonymous in the sense that don't say, I've got this problem. Just say, just mention it, a person I know, or what if, and we can do it that way. And I'll just get the comments up for here live. So bear with me. Right, that's right. All right, Casey's here. Hello, Casey. My first comment on the show tonight. So if we go to this screen here, you should be able to see. Uh, Hang on, can you see in the screen there the blog? Yes. Okay, great. So that's the sort of agenda for tonight, and you can get to it anytime by just going to WFLAG blog, and it'll be there. Hopefully with a link to this video as well once it's up and running. So on last week's show, I was talking about the problem faced by refugees who've been granted asylum. They get given very short notice to leave their home office accommodation, and they're expected to make their own way to a local authority and make an application and get accepted, well, get temporary accommodation, which is often difficult for them, not least due to language or, uh, acclimatizing problems or mental health issues arising from trauma. But it's made more difficult by the fact that local authorities are often gatekeeping, not always, but often. And refugees are easy people to, in the eyes of people who are going to gatekeep. If you're going to gatekeep someone who doesn't speak very good English and can't really argue with you is a good target, unfortunately. So I said last week I would show you a letter which you can send in accordance with the Judicial Review Pre-Action Protocol, warning a local authority that judicial review proceedings will be issued if they don't process the homeless application and give the person accommodation. So I'll put it up on screen. You can click that link that I just clicked on the thing there, and you get this. Now, this is a Word document which is saved in Dropbox, so you should be able to download it and edit it. I'm not going to go through every single bit of it, and I apologize, I've done the sort of usual corny thing that I've changed. This is based on a real letter, and I've hopefully anonymized it, but in doing so, I've used corny names for the local authorities and the addresses are all EastEnders related. And for the really old people present, there's a reference to Brookside as well. Um, so, um, what you need to do is send this letter with a deadline. I mean, usually you can give it a normal deadline according to the Judicial Review Pre-Action Protocol is 2 weeks, but here you can give them less because it could be urgent. The person could be on the street, so you could get away with giving them 4 hours. Tell the story. It doesn't have to go into that much detail. It could just be Mr. Smith's applied to your council. He's got a medical condition and he's homeless, and you haven't done anything. That would probably be enough. The issues here are the legal issues that mean the council's acting unlawfully, and you could just copy and paste these. They basically say that a council needs to process an application and give someone written notice of the application, of the outcome. They need to make inquiries into that, and they have a duty to provide temporary accommodation to people who they have reason to believe might be in priority need while they do that. And there's a bit about local connection there, because one of the reasons that people often get turned away, and unfortunately the councils are often entitled to turn them away in the long run, but not in the short run, is local connection. And that's to say, if the person hasn't lived in the area for long enough or have other connections, family associations, or employment. But what the council are supposed to do is, if they think the person's owed a duty because they're homeless or they might be homeless, eligible and in priority need, they have to give them temporary accommodation whilst they make a referral to the area where they have a local connection. But what they very, very often do in this type of situation is just refuse to process the application at all, because that's what they used to be allowed to do. Um, well, in fact, they weren't even allowed to do that. They still had to do a Section 184 notice, but they could print one of those off pretty fast, just saying you've got no local connection. But now they often just say, go back to where you came from in terms where your your home office accommodation was, which is pretty awful if you're in a central London borough and your accommodation was in Liverpool or something, because you can't realistically go back there. And anyway, you haven't got anything to go back to. Well, you could apply to Liverpool City Council, um, but that's a pretty awful prospect if you're stuck in London and you haven't got much money to travel. And so then it says that basically says what should be happening, and that the council's acting unlawfully. And then it says that they expect the council to process Mr. Smith's application and provide him with accommodation. And I've stuck in there and make arrangements to store his belongings if he's got any. But probably if he's coming from home office accommodation, he might not have very much in the way of furniture and stuff with him. And then give the contact details of the person and the deadline, and also stick in a subject access request while you're at it so that you can get the copy of their file. And now you may say, well, who's writing this letter? Is it the applicant themselves? And if it is, and if they've got somebody to help them write the letter, um, you could say I'm helping Mr. Smith rather than I'm instructed by him. Sorry, I've left that lawyer bit in there. Or Mr. Smith could just write it. I can do another one later. I think I'll do a longer video about this, and just explain how it's done. But I thought, because last week I said I'd give you a preview of what a letter looks like, that's what I've done. But I won't go into too much detail unless anyone's got any questions about it. Nope. Okay. Um, so let's go back to the next thing to talk about. And again, this is something I
I
thought. Yeah, sorry, Shannon.
I would say it's not a question, but I often find with template letters and stuff, and I know I'm making more work for you, so apologies, but it's quite helpful to like have bits that are highlighted, so it's just really clear what the person's like swapping out of that information. Particularly if someone doesn't understand the law, they might not
Yeah.
understand even that that's the bit that they have to change. So making it really clear the bits that are specific to that individual's
No, there's
case.
sort of, yeah, you're right. Um, what I'll try and do is do a more simple one, um, as well, because there's more information than you need in there. So yeah, the next thing is sort of similar in a way, but not exactly the same, because something we've talked about, or people ask questions about, is how to issue a homelessness appeal. And one of the reasons why it's important that people know how to do this themselves if necessary, is that there's a 21-day time limit for issuing the appeal from the date when you receive the review decision letter. And although courts have a discretion to um, allow an appeal out of time, they are really mean about the way they apply that. And a request for an appeal to be allowed out of time, based on the argument I was trying to find a solicitor, is likely to fail, because judges are not that sympathetic, believe it or not, even though they should be. But I think I know that at least one leading judge has made comments to the effect that it's a load of nonsense, that people find it hard to find solicitors, and anyone can find one, which may be the case if you've been a barrister for 30 years and become a judge, rather than um, a member of the public. But there we are. Um, so what I will do, I think I'll make a longer video about this, but I'm just going to give you a flavour of what you need to do, and show you these documents. And so that if you were desperate now, you might be able to just use these documents to do it. Um, Before I start clicking on things and maybe distracting people from the actual what I'm saying, um, all you have to do to get an appeal in is fill in the appellant's notice. Sorry, I've called it applicant's notice. It should be appellant's notice. I'll edit that. The N161 form. Send that to the court with a grounds of appeal and an email asking them to issue it. And you may get it rejected if you don't offer to pay a fee, which is difficult to do if you don't have an account. But you can get exemption from paying a fee if you fill in a form and send it to the court. Um, but as long as you're not having this conversation with them on sort of day 21, there should be time to sort out any queries. I'd be interested to know of any problems people have with this, because unfortunately, because I don't usually act, the people I'm dealing with, I can pay the fees when the legal aid agency pay me. I never have to make an application for exemption. Um, so I'll just show you what you need to do. And I'll show you that this form, when I open it, it may look a bit daunting. And you think, oh, I could never fill one of those in. Uh, but it's not as difficult as it looks. Does it look daunting, uh, guys? Or maybe I'm just, you
I
go
think
through all,
if it's new, I'd be daunted by that. But I think that's just the nature of,
yes.
yeah, just kind of like, yeah, just trying
But if,
to. There'll be jargon in it without even realizing there's jargon.
yes. And you may think, what do I do about what's a fee account number? But this is intended, it says if applicable. And uh, the other thing that makes this more complicated than it needs to be is that this appellant's notice was designed for people who are appealing against court judgments. And so it's asking you questions as if you've got an ongoing court case and you're appealing against some judgment, say making a possession order against you. Um, but so that's why it asks for the claim number, but there isn't one here. So really, all you'd have to do is fill in your name and the name of the council, and again do the same thing here. Put your address and address of the council. That would be on the decision letters that you've got, and the decision that you're actually appealing is the review decision letter, which you should have, and that'll have the details on it. They've still got faxes. I think most people now stopped using faxes. Um, so don't worry about that. Although some local authority writing paper, I think, still has fax numbers on it. But and then what you can ignore all this because this is the details of the appeal. It's asking you which court it was. I mean, I normally just put homeless appeal in a box. I can put some text in here and say homelessness appeal, and they'll realise what it is. So I'll just scroll down. If you obviously you don't have to fill in box 3 because you do, well, except put no, I haven't got legal representation. The council won't have legal representation either at the moment because the case hasn't been issued, so they won't have instructed their legal department. So that page can be blank. You don't need permission to appeal, so you can ignore that. That's where you're appealing against a court judgment. And then the order you want, that bit you would fill in, section 5, which says basically it's the decision that I'm intentionally homeless or something like that. You don't need to go into huge detail. And then say, have you lodged it in time? If this is less than 21 days from the date when you got the decision, yes. Then there's some, it asks you about a skeleton argument, and you can just say that it'll follow within 14 days. It probably won't, but nobody's going to send you to the Tower of London if you don't get it in there. You'll just get some automatic directions, which I'll come to later. the Aarhus Convention, just when you were thinking it was getting easy, let's stick that in. But no, you'll never ever that. I don't even know what the Aarhus Convention is or was. It's it's something to do with town and planning, but you can tick no for that. I know that Aarhus is in the middle of our street, if you're a Madness fan, and it's also in Denmark. But that's about it. So forget that page. Then what you're asking the court to do is tick vary. I mean, you could just say set aside the decision I'm asking about or vary it. Um, you don't need to just say more than that. Now, you're not generally going to be making any other applications. We've talked before, I think, about what happens if you need temporary accommodation while this is going on. But for the sake of this, I would leave that out for now because you'd have to issue a second appeal, a Section 204A appeal, if they've refused to give you accommodation pending the outcome of the appeal. But they won't have refused it until you've issued the appeal or shown them the appeal. So to keep it simple, this is just really to save you from being outside the 21-day time limit. It's not to enable you to sort of put in something really good. But it's enough that it's not bad enough that it won't get chucked out. You don't have to put any evidence in there at this stage. Vulnerability. So you may think, oh, if this is a case about intent and priority need, then I need to tick, or if I've got a medical condition, but it isn't about vulnerability. Just to make things more difficult, it's not about vulnerability in the homelessness sense. It's about whether you are vulnerable in that you need support from somebody in the court or something. Which may well be that the person would be vulnerable, but you can be vulnerable in the homelessness sense without being vulnerable in this sense.
Is there anything to lose by asking for that?
No,
I mean,
if
if you
in
had some
doubt,
kind
you
of
might want to
like,
put yes.
I mean, because I just think if you can have someone in the court to help you out, then okay, well, great, go for it. I mean, does it delay things? Are they going to struggle to find someone to
Well,
actually?
I've never actually come across where somebody ticks that where they sort of get in touch. I mean, and say, do you need any help with? I mean, if you did say, look, I'm sort of confined to a wheelchair or I've got limited mobility, then they might say, oh, well, we thought we'd contact you because most courts have got disability access, disabled access. But yeah, it can't do any harm to say you're vulnerable.
I mean, if you said like, you've got serious anxiety or something, or you've got dyslexia or something like that, then those things would be
Definitely,
presumably something they could help out with.
definitely. Yeah. So put yes if you're in doubt and you think you might need some help. I mean, it's difficult enough being a litigant in person, so put yes. And then statement of truth. Actually, you don't really need to sign that because the statement of truth only means that you're saying that what's in box 11 here is true. If you see it says this must be completed in support of the evidence in section 11, but I'd just sign it anyway and say I believe the facts are true, and then date it. And don't worry about this stuff here. You can ignore nearly all of that. Ignore that, and just sign it down here. In fact, it's assuming, this is interesting, it assumes that nobody's going to do this themselves because it's saying appellant's legal representative. But it should really recognise the fact that not everyone can get a solicitor. So if you've managed to navigate that, and I'm sorry that was a bit of a sort of whiz through it, and again, I can go into it in more details another time, but it's just to show you what it is. And you can get it off you can download it if you click on the link that I got to get here, which was on the blog here. You can download your own one, and you can either print it off and fill it in by hand, or do it online if you've got something that edits PDFs. Now this is the grounds of appeal. Now this is something that many people may find challenging at first because you think, oh, you need to be a lawyer to draft grounds of appeal. And you are right in the sense that by the time it gets to the final hearing, you will need to put in detailed legal arguments. But for the purposes of this hearing, you don't. Sorry, for the purposes of issuing the appeal, you don't. And the main reason for that is because the court, the Central London County Court, which is where I would advise you to apply to, automatically issues directions, and they're always the same directions. And there was a webinar I went to which had Jan Luber, who was the judge in charge of homelessness appeals at Central London County Court, and I think was a guest on one of your previous videos, Mike. But he was asked the question, how do you get the court to issue directions other than their standard ones? And he was saying, well, the judges are sort of on autopilot at this stage. They do, in theory, approve the order, but you would literally have to write over your appeal in red sort of ink and big letters, do not issue the standard directions. I want different directions. But for here, we might as well take advantage of that, because the first two directions usually on a standard directions order are: number one, the council has to give you a copy of their file within, I think, 14 days or X number of days. And then from the date when you get the file, the applicant or the appellant has got 14 days to amend their grounds of appeal. And they've got 21 days to put their skeleton argument in, which basically is the script for what they'd be arguing at court. And so that, and it'll take the court probably about a month to issue the appeal and send out the directions. So you're looking at 6 weeks. And so in that time, you've got, I'll come on to it, but I think in that time you should be able to find a lawyer who can then get the copy of the file, get a legal aid certificate, and instruct a barrister to put in a proper grounds of appeal and skeleton argument. But just so that there's something in there which answers to the name of grounds of appeal, as it were, I've created this thing here, which I'm sorry about the fonts. I mean, I did do it all in one font, but it seems to have saved it in different ones. But you may think this looks a bit complicated, but it's not as complicated as a lot of grounds of appeal. But what this does is enables you to put your name, the name of the council. That's all you need there. And then it says here, these grounds are submitted on an emergency basis, and that you propose to file an amended grounds of appeal once the respondent's file has been received and once the appellant has obtained legal representation. And then what you can do is say what the decision is. And so, oh, that's interesting. Yes, they're usually, there's about 6 different possibilities for what you're appealing. It's either going to be a decision as to whether a duty is owed to you or not. It'll be a reason why a duty is not owed to you. So the council could have said you're not eligible, you're not homeless, you're intentionally homeless, you're not in priority need, or you don't have a local connection with us and we're referring you off somewhere else. So those are the 5, tell me if I've missed one, but those are the 5 sort of hurdle type appeals. And so you can just stick in here, the appellant asserts the respondents made errors of law in reaching the decision that he or she is, and then you can say not homeless, and I put the things down here, I should have put them up there. So then you've got the grounds, which are always going to be the same at this stage. So the respondent has misdirected itself as to the meaning of, and then you insert which of those issues it is: eligibility, homelessness, priority need, attentional, for the purposes of part 7. So you can just delete the others. So it's got the one that fits you. And suitable, if you're appealing against a decision that you've refused or suitable accommodation or something, it's going to be suitability. And you're saying there that the decision that the property at XX, or they put in the address, was suitable for you. So that's what you're challenging. And those will always be the same, because you're saying they failed to make adequate inquiries into your circumstances. They failed to oh, sorry, I've missed one out, but it doesn't matter for now because you can always add it later. I would have said they failed to assess you properly for the purposes of 189A, but then you can say they've acted irrationally, and irrationality is a term you may sometimes hear in this context, and there's lots of argument about what it means, but I tend to mean that I tend to treat it as meaning that they fail to have regard to relevant information and they've had regard to irrelevant information. So that would be, for instance, you can't be in priority need due to vulnerability because you've got a job. That would be irrelevant, because you could easily have a job and still be vulnerable. And then you say that those amount to errors of law, and then you put your name and a date, and that's it. And then you email that to Central London County Court with, so you'd need to send your application for exempt. Oh, I haven't talked about that yet. Well, I mentioned it in passing. Basically, I don't know a lot about it, but if you read this stuff, it'll tell you how you get exemption from paying the fees. And you can apply online, which is easier. And I think what you're going to need to do is show them that you're on universal credit or any other benefits that you're on. And they may want, I'd have thought they would, because what they're saying here is that you've got to have a certain amount of savings or less than a certain amount of savings, but I don't see how they can know whether you're telling the truth or not without seeing your bank statement. So they may need those. I'm sorry I can't give more information, but like I say, I've never actually filled one of these in or helped somebody fill them in. But then you can send that off. You might just want to send it off, and if they reject it, you can then ask them for help on what you do to get the exemption from fees, because they may still treat you as having filed the appeal within time, even though you haven't paid the fee. And that might be something the judge would give you some leeway on. And that's the email that you send the stuff to. And that's it. So I hope that helps, in the sense that that would enable people, if you could follow what I've been saying now and listen to this video again, or wait until I do a longer post, a sort of step-by-step one, you could issue your own appeal and avoid being out of time. The one thing I would say as well is, this may sound a bit cynical, but I think when people report that they have difficulty finding solicitors, it's often because the solicitors are cherry picking, which is, I think, sort of a relative of gatekeeping, but it's sort of, they're only going to let cases through that they want. And what solicitors often are looking for is cases that will pay better than other cases. And as a homelessness appeal, out of the different sorts of case you do, pays better because it goes straight to a full legal aid certificate. So I won't go into more detail on that, but I would say that if you call a solicitor's office or email them and say, I've just issued a homelessness appeal, I need a solicitor to take it on, you're more likely to get a positive response. And if you get, just to prove that, if you've got the link to the Virgo solicitors form that we use for new clients is on the link to the video here. So if you click on that, I'll put it on here as well. But I mean, if you can get this far, or even if you've got to the point where you want to issue the appeal, I mean, send us a message and we'll try and take the case on. But I can't guarantee it. But we are training people up at the moment and trying to increase capacity, because I'm just getting bombarded with requests every day to take on cases. I've just remembered I haven't replied to 2 messages I got this morning, which I must do after this. So that's the end of that section. Anybody want to say anything?
I think it'd be interesting to see how you can do it in as a step-by-step video, because I think I'm already flummoxed by that in terms of just kind of thing.
But,
No, it's just because it's genuinely it's a lot of stuff that's going to be new to people who are not familiar with the court system. And like, say even terms like high court, if you're not a lawyer, you don't actually know what that means. You're like, well,
right,
that's scary.
Right.
So I think it'd be really good to kind of to really break it down, and kind of just kind of have that sort of very much step by step. I think that could be really useful. So I think it's worth doing. I just think it requires kind of almost like maybe a couple of examples as well, like, vulnerability case, a gatekeeping case or something like that, just to sort of show people what kind of things will go into the blanks.
Yes, I agree. I've got one more comment which I will try and bring up onto the screen. It's not very clear, is it? If I put it, oh yeah, there, that's better. It's from Tiff, and in fact, that's not the question. That's an old question from another show. So if I get, my comments up, I can hopefully show you this one. Comments, reaction. So it's this one. Yes. What's the name of the judge who said it's not hard to get a solicitor, please? Well, before I mean, it's Jan Luber, or His Honour Judge Luber, and I'm not. I don't want to be. I don't want to sound sort of like I'm backing down on that, but I heard that he'd said that. If he was with us now, he might say, "Of course, I didn't say that. I know how difficult it is." But I heard that he'd actually used quite a strong expletive about it. But I may be wrong. So sorry to Jan Luber if I am wrong about that. He knows that I'm a big fan of his. So that's that one, Tiff. And I will go on now to talk about these other cases that were reported. These are fresh off the press, as it were. Let's get rid of that. No comment. Where's it gone? Sorry, it's still there, isn't it? I'll just take it off. Right. So we've got two cases to talk about now very quickly. Well, we've got half an hour, so or 28 minutes. Now, you said, Mike, you've read the Davishi one. If that's how you say it.
I've not yet. I've not read it. Every
You
single
read
thing.
the
But I've certainly kind of picked out some bits which struck me. So yeah, I've got it up in front of me now. I'm just kind of going maybe the last sort of like 10% of the paragraphs. But I think I've seen the bits which I think are going to be the bits which are most useful for people.
Well, these cases were both. I think Giles Peaker did a post yesterday and referred to both of these, and so they're both interesting cases, and so I've gone through them, and they both have. I put them onto the database, which, if you remember, the database is available. I'll just show you that. But if you go to case law database, whoops, and then go up here. Sorry, I'll bring this up. So if you can see the whole of that, but this will show you the cases that have been added in the last week. Again, some of these are like old cases, like Fazy v Brent. I've forgotten why I added that, but sometimes if I'm reading a judgment and it refers to another case, and I think, oh, I should have that on there. This was actually, it's one of those funny things. I found out. I thought this is an interesting case. I better read about it. I wonder what's out there. And I found that a very old post from me was on here. I'd actually done a post about it, but I'd forgotten. But it was about the futility of trying to get temporary accommodation pending. Yes, that was about Section 204A appeals. So if you're interested in Section 204A appeals, which you'll remember is what you need to issue in order to get temporary accommodation pending the outcome of an appeal. Back at the time when that case was decided, which was 10 years ago, it was so bad that my post was called "No Right of Appeal at All." I think it's got a little bit better since then. But what we're talking about today is the case. So should we start with Burke Noel, because that's the first of the two, versus Lambeth. And I've put some notes. So if you want to know more, I've put the actual judgment. It's embedded on there. I also got the Nearly Legal post on there, so you can go to that and you can get a medium-long summary on that one and a very short summary here, but also less thought out. And there's the whole thing if you've got time to read it. So this case, as with many these days, is about suitability. That seems to be the sort of big. I mean, if you had to do a pie chart of where the court cases are on homelessness, I would say that in the old days it used to be sort of intentionality, vulnerability. Nowadays, at least half the pie chart is suitability. And there's two different ways in which suitability arises. The most common way is that somebody gets offered something and they don't like it once the council has accepted a duty to house them. And the other one is that they are saying that they're homeless because their accommodation is unsuitable or unreasonable to continue to occupy, and the council disagree with that. And what happened in Actually, the first of these cases is suitability concerning rejection of an offer, and the second one, which we'll come on to, is whether the person was homeless because their accommodation was unsuitable for them. But what I won't go into huge details on this one, other than to say that the applicant had a son with special needs, and the council offered her a property, wasn't too far away from the borough, but it was far enough away for her to consider it quite rightly to be unsuitable. And the appeal that she asked for a review, and the review was unsuccessful. So she appealed it, and she won at the appeal stage. And what this case is useful to remind everybody is that it's easy to. So when people do suitability reviews, they're often just going through the motions, because what the council are thinking at the time when they make the offer and when they deal with any challenges is, what are you expecting? We haven't got anything. There's so many people applying. Be realistic. And there may be a little bit of mileage in that, but the point is they still have to consider people's circumstances properly. And often they're only going through the motions of doing that because they've already decided, oh, stop making a fuss. We'll get away with this because the judge will recognise that we're up against it. We're trying to house people. So if you scratch the surface of a lot of decisions, you will find grounds for challenging them, which you may not have spotted on the face of it. And this is what happened here. That and I've put that the thing I always forget to do is that you should always I'm going in reverse order. You should always try and get the local authorities. Whoops, I haven't got. They've got a policy. It should be called. What's the word? It's a policy for placement policy. I think it's called. I'm going to type it on there now so you can see it. So get their placement policy, because they're supposed to have a written policy document saying how they deal with placing people out of borough. Because the starting point for suitability is that you should have cows within your borough unless it's not possible to do so. So the question is then, what if it isn't possible to do so? You have to have a written policy. And this is where Waltham Forest have got into trouble in the past, because they say, oh dear, we haven't got any accommodation in Waltham Forest, so here's somewhere in Newcastle. And obviously the complaint about that is, well, didn't you have somewhere maybe a little bit closer? And they did have, and they've come up with a policy, which I won't go into now, which says how they do that. But you need to check each time that they've applied that policy. And you may well find that nobody actually even opened the policy up. And there was a very technical argument here that they hadn't applied their placement policy. So that was something they got. Then this was another case of the person said why they were rejecting the offer, and they gave the reasons. But then the reviewing officer, they come up with some sort of very haughty turns of phrase. Like, you say to them, my elderly mother lives with me and she has difficulty climbing stairs because of her arthritis or whatever, or a mobility problem. So this property's got a steep flight of stairs and it's unsuitable. And then you get a response saying, I hear what you say, but I can see no evidence or no reason for treating this property as unsuitable. You think, well, I did actually tell you, but in this case, they did something similar. They just didn't give adequate reasons. It was a sort of stop making a fuss type answer. So they lost on that one. And this was what was interesting on this one. This is, I mean, Lambeth do tend to make mistakes like this one. So during the process when they were making investigations and assessing, the council had a form about suitability, and the form had two questions on it. One was, is there any particular reason why this person should stay in the borough? And they ticked yes. And they said, does any child have a special policy in place at school or program at school, which means they can't change schools? They said yes. And so then The reviewing officer completely ignored that. And so they said, well, look, your own staff have said that this person can't change schools. And they'd done the usual, oh, your son can change schools bit in the decision letter. But to make it worse, nobody nobody knew why this guy had ticked the boxes, because he hadn't put any reasons and he hadn't put any details. But they said that, and so they tried to argue, oh, well, he just made a mistake. But the judge said, no, you can't, you've got to explain that one, because he was probably onto something. And another one they did in this, which I haven't put, the 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 I'm pretty sure it was this case. Yes, it was. I don't know, maybe it was the other one. But the point is true. This is another example of how bad reviewing officers can be, and how you may not spot it at first, but you have to just sort of stop and think. But one of them said this property is a fire risk because there's loads of stuff sort of left in the hallway. And the housing, when I viewed it, the housing officer said, "Oh, just leave your stuff in the hallway. It's all right. Nobody minds." And so they said that's a fire risk. But then the reviewing officer rejected that on the basis that they had some photographs from the estate agent which showed nothing in the hallway. So we got the usual, there's no evidence, and I've got evidence to show there's nothing in the hallway. But of course, they hadn't figured out when the picture was taken. And obviously, they wouldn't have said there was stuff there if there wasn't. So this wasn't an adequate response. So the last point on this case, which is again good to see, is what they did was, I think the judge called it a concerted attack on the council's decision making based on the public sector equality duty and the Children Act 2004. And just to remind everybody, the public sector equality duty is a duty to make sure that when you make any decision, you're doing so in a way to minimise mistreatment of people with disabilities. I think that's the simplest way to put it. So you've got to have that in your mind. And similarly, the Children Act 2004 says that you've also got to have in your mind the extent to which your decisions impact on the well-being of any children involved. And it's quite easy for councils to get over that hurdle because they just have to say something like, I've given very careful consideration to your disability, and despite that, I think this is suitable. And similarly, they could say, I've thought about your children, but it has to be something that's compatible. They can't say, I've thought about your child who has special needs and needs to be in a particular school, but nevertheless, I think you can go to Newcastle. That might be irrational because judges have said in the past, there's more to considering your duties than just reciting a mantra. So they fell down there because they just hadn't thought this child had a disability. The child's interests were concerned. They hadn't thought about that, so they lost. And the other thing that I put on here, one thing. Oh yeah, there was two things. I haven't put both of them. One of the reasons this lady objected to the property was she said it was in a state of disrepair. The judge rejected that and said that disrepair wouldn't be a reason for treating somewhere as unsuitable because there are mechanisms for making sure the work gets done. Now, when I read that, I thought, well, that's true. And I often get clients saying the property's unsuitable for me that I've been offered because it's in a state of disrepair. And I say, well, is it something that can be put right? I mean, if you said it's in a state of disrepair because there's a great big hole in the ceiling and water's coming through, I don't think anyone would expect you to treat it as suitable. But if it was just that there's a bit of damp in the bathroom, or the kitchen units are loose, then you couldn't use that. And the other thing that the applicant got criticised for by the judge was there was talk about the child needing to be at the particular school, but they hadn't got any evidence from the school. And the judge said it would have been helpful if you could have got a letter from the school saying what the child's needs are and what you think the impact would be of leaving. And the same thing about the doctor. If you're going to mention medical needs, you want to get a medical report if possible. Which brings us on to the second case. If it's okay, unless you want to talk about that one, I'll just jump straight on to the second one, and then we can talk about the issues. Or do you want to talk about that one?
No, I just thought it's just nice to have two cases in a row which are like positive and
Yeah,
kind of seem to be like a good thing for homeless people and people in this sort of situation.
yeah. So that one is a really good case for reading and thinking about how to actually look at challenging the suitability of something that's been offered and the sort of things that the council may not have done, which may enable you to get them. Because the point to remember with homelessness appeals is, and as it's the same with judicial review, it isn't about saying to a judge, you don't think this property is suitable for me, do you, Your Honour? And the judge saying, no, I don't. I could never live there, so I'm going to allow your appeal. You've got to think of it like a maths class at school, where they're not so much interested in the result you get and the answer, but they're more interested in the workings out. So if they can see that that you haven't considered the needs of a disabled child, then that's the workings out, that the process is flawed. So you've got to look at all the things they should have done and what they didn't do. And normally between those two, you'll often find at least a couple of things that might win an appeal for you. Which brings me on, and maybe I can see there's quite a few comments coming in from, I think, all from Tiff actually. If it's okay, Tiff, I'll come back and answer those after this. Because this case is really good. I really felt good after reading this, or during while I was reading it even. This is about Now Medical, our favourite organisation that are described as the council's medical advisors and have been acting that way for a number of years. And anyone involved in challenging decisions usually gets frustrated because, and I have to be careful because Nick Nicol, who put a YouTube video up criticising Now Medical very strongly, I think got a letter from their solicitors. So I'm not going to say anything about what a disgrace it is that doctors should be behaving like this, but somebody might. So in this case, there was you have to go back to a case called Sharla, which was a really great case in 2007. And what had happened in that case is a woman, or I think it was a woman, or the applicant had a medical condition which was relevant to the case and had a report from a consultant psychiatrist confirming it. And so Birmingham City Council sent the report to Dr. Keane, who was a GP and was at Now Medical, and he put in a report himself, having not examined the applicant or met them or talked to them, but just basically writing a critique of the evidence given to him, saying that he didn't agree with the consultants and didn't think there was grounds to uphold what they were saying. And what the court in that case said, that you can't rely on a GP to challenge the evidence of a consultant, especially where they haven't carried out an examination. Um, so in this case, since then, I think at that time, after Charlotte, before Charlotte, correct me if I'm wrong, anybody, but Now Medical didn't actually have any psychiatrists. I think they just relied on Dr. Keane and one or two other GPs. But then they started getting psychiatrists to work for them. And so they got two in this
I'm not
case. Sorry, go on.
so I might be wrong here, but I think I think Dr. Keane and some others there have got some psychiatric qualifications, but I don't know that they're not. I don't think they're psychiatrists. And
Well,
I've just noticed that they've actually got a Wikipedia page, like Now Medical, and I wouldn't be surprised if it's written by Nicholas Nicol because it cites a few things he said before. But I don't, as I say, they're kind of they're members of the Royal College of Psychiatrists, but I don't think that means they're psychiatrists.
no.
So I'm not quite sure what their qualifications are, exactly what they
Well,
mean.
well, let's say that they were people described as psychiatrists, I think, by people involved in the case. And for the sake of this, if it's okay, I'll just refer to them as two psychiatrists because there were two from Now Medical. And so the for the this applicant, Ms. Davishi, I should explain just by way of background that Ms. Davishi was a survivor of God, my memory's gone blank. West, what? Sorry,
She was
the
she lived at Grenfell, like her
Grenfell.
family did.
Sorry, yeah, that's the word I'm looking for. Sorry, she's a survivor of Grenfell, and she became homeless and was picked up and put in accommodation which was unsuitable. Now, this is a very common problem that I get. Is that I mean, it's almost the most common unsuitability issue I get, apart from families with children being put in places with damp. But it's where a single person gets put in a place in multiple occupation, uh, which could be a converted house, or there's a couple of notorious addresses. There's one in Waltham Forest where everybody seems to end up. Um, and what we call supported housing as well can often fit this description. So you've got loads of people running around all night in the corridors shouting, and if you go out and challenge them, you get threatened and stuff. And there's lots of drinking and smoking, uh, which is not a good environment for anybody. Well, for anybody really. And especially people with post-traumatic stress disorder, which I mean, I won't go into all the qualities, but it makes you hyper vigilant and very sensitive to noise and stuff like that. So this lady is suffering from post-traumatic stress and related conditions, such that she gets a psychiatrist report saying that this type of accommodation is not suitable for her. It then gets referred to two psychiatrists from Now Medical, and they again haven't examined her, but they read the report and they don't actually say this report is rubbish or we disagree with this. They make a couple of sort of critical comments like the report is rather short, or they refer to him as the psychiatrist paid for by her solicitor, that sort of thing. So it's sort of not endearing terms. And so they ignore the report, and the reviewing officer compounds this by sort of joining in and making negative comments um, based on not what's in the medical records, but what isn't in the medical records. And this is quite amazing, really. So they're saying, well, if you went and asked, well, you asked to be, you said that you thought you were well enough to go back to work, so that's incompatible with a finding of post-traumatic stress disorder. And if you had been so worried about your mental health, you would have talked to your GP more. Can you believe? Hard to believe. And the judge said, well, maybe the judge did observe that maybe they should have thought that it was the post-traumatic stress disorder made it less likely that somebody would want to have a chat about it. So they went down that road, which is basically getting it's basically Sharla again, except they've used psychiatrists instead of a GP. But they've gone, I think it's worse in that they have tried to make these points about the medical records. And I should add that I had a flashback when I was reading this, that the barrister, I did a case once which involved a psychiatrist report, and I had to sit and listen. It was actually the barrister in the previous case, Burke Noel, I think it was Michael Padgett, who ran this argument. So I think a lot of them, I think they've got these arguments set up. Um, But he went through the medical records in our case, and the starting point was so basically there's no such thing as psychiatry or mental health analysis. There's just somebody repeating what the patients told them. So that's all a psychiatrist does. You go in there and say, oh, I'm feeling really, out of it. So the psychiatrist says, oh, he's feeling really out of it. That's all they do. And then you have to go through the medical record, and you'll see that on sort of this day, the 4 years ago, there's an entry saying seems to be all right at the moment. So, oh look, he was all right then. So the psychiatrist was obviously misled, and this went on for ages. Fortunately, the judge didn't give it much shrift, and but that's what they were doing here. They were sort of saying that the medical records are reliable, but everyone knows that medical records are not the record of an assessment. It's not like a report. It's just half of, if you read someone's medical records, half of it is just standardized stuff that somebody sent them a text message about COVID, or they've come in for a routine test. It doesn't really tell you much, but they actually tried to not just prove something from what the medical records said, but what they didn't say. And the judge said, no, that you can't do that. And this is the really good point that came up in both Charlotte and this case, is that in Charlotte it was suggested that if a local authority disagree with an expert, they should do other things rather than just ignore it and rely on somebody who they prefer. And one thing they could do is instruct a second expert, which is somebody who actually examines the person. Or failing that, they could write to the expert who, as in this case, who'd done the report about post-traumatic stress, and ask them questions and say, we've noticed that in our medical records it suggests she was able to go back to work. Does that mean you think she wasn't suffering from post-traumatic stress disorder, or how do you reconcile these? And it's pretty obvious the psychiatrist would give a perfectly good explanation, because the two things are they're not mutually exclusive. But they don't do that because they want to just try and sort of blag their way through it. But the judge said that's what you should be doing. And hopefully, if it comes up, so what I've said here, my points that I've done some takeaway points on here, and this ties in with the other one, that if you're going to raise medical points, and this is for lawyers or people advising, get a report from a lawyer, from a doctor. If you're going to raise medical stuff, get a report. GPs are not the best people for providing mental health reports, because they don't generally deal with mental health. I think I'm not being unfair, but they would probably tell you themselves that they're not really trained, or they would, if they have suspicions that a person's got a mental health problem, they'd probably refer them to secondary mental health services. So you won't get very much. So, I mean, some GPs, obviously, I've had fantastic reports on mental health from them, but you want to get a consultant psychiatrist. There's no way around that. And the legal aid agency will pay for that. And if you win, the council will pay them back. So you want to get that, or other specialists. You know, if you've got a report that says somebody can't manage stairs, you may get a GP who can actually say, yes, this person has mobility problems, and we prescribe them painkillers or medication. But you may need to get a consultant to say, yes, they can't manage more than three sort of flights of stairs, 3 stairs or something. And then when the council refuse to accept the findings of the specialist, you should ask them to say why, because they didn't do that. They didn't say we disagree with the specialist. They just said there's other things that make the specialist look silly, but they couldn't really bring themselves to say they disagreed. So ask them to do that and invite them to put questions. Say, we can see you've got doubts. Why don't you put questions? And then point out to them that relying on doctors from Now Medical who've not examined a patient, or relying on the reviewing officer's amateur diagnostics, because it's amazing how much reviewing officers stick their necks out and say silly things about medical conditions, which then when they're not, they end up looking silly. But I wouldn't sort of say I believe that somebody's medical condition is X, Y, and Z, because I'm not qualified to do that. But they do this, so it won't be a suitable substitute for the opinion of a specialist. And I'd just like to say that both of these judgments involve Daniel Grutus, or the barrister who acted for the appellant in both cases. And it's a tribute to him that he's got both of those off the ground, and he's done some other excellent cases. And I've had the pleasure of working with him on a few cases which have been really good, and hope to continue doing that. So that is the end of that. If you've got any questions, I'll just come to Tiff's. Tiff's put a load of questions in here. If you don't mind, Tiff, what I would do is I'll read them out rather than put each one on the board. But is that okay? So Tiff says, yeah, you've asked me what the name of the judge was, and said, then you said, vulnerable tenant requested from DWP copies of all phone calls. Royal Mail, I suspect, didn't get signature from DWP. No name and photo, not of envelope. Received nothing. I'm not quite sure what to say about that, other than it sounds like You may have got messed around. Now I'll keep going though. It was an expensive special delivery. Is it legal if Royal Mail signed and just photographed a pile of different envelopes? Also, if send again, are Royal Mail allowed to sign? Ooh, I don't know if that's something you guys know more about. I'm afraid I don't really know about the Royal Mail. Then it says vulnerable tenant was never informed by DWP or Universal Credit of mandatory reconsiderations. Are DWP allowed to legally deny transcripts of phone calls and copies of phone calls? Well, I think we could answer that by saying if they have records of calls, then they are obliged to disclose them. So you couldn't legally, I think they would be very foolish if they said, we've got these, but we're not going to give you them. What do you think, guys?
So I think if they have them, then yeah, but I don't think they keep them. Or if I think they the whole recording thing, I think is done in a way which specifically kind of it prevents people getting hold of them. So whether it's they're not made in the first place, there's no transcripts, or whether there's some immediate deletion policy or something, I don't know. But I've never seen a phone recording ever kind of discloses in a subject access request.
Yeah, I mean, sorry, Shannon, go on.
I was just gonna say I've known one person to get a transcript from the DWP, but it was because their appeal was done over the phone, and so it all had to be recorded for that purpose. And so when they made a subject access request, it was in there, but that's because the actual sort of appeal and everything else was done on the phone. But when other people have tried, it's not been included because for reasons Mike's just said.
Yeah, so yeah, I mean,
but you could always record it yourself. Like if you particularly I know not everyone has like a second phone, but on your phone you can do like screen recordings. I think you have to set it up before the phone call. Basically, practice with a friend if you can first to make sure that you're actually recording it and stuff. Because it took me a good few times. But you could do a screen recording on your own phone, and then you'd have a copy of what was said and stuff.
So I hope that answers that. If you've said it's all rather shady, isn't it? And I agree. And I suppose there will be a day in the future when technology allows all the calls to be recorded and sorted and disclosed, but we haven't got there yet. And so that, I think, is everything, unless anybody wants to talk about anything else. I'll keep reporting the cases. I think it's really good to have a chat about these, because I used to read all these cases and then I would forget about it. I mean, I still do, as you can tell that I've forgotten that I've even written a blog post about one of them. But it means that I can share some of this with other people while I'm reading them. So I think that what we've learned there today is that it is possible to, we should keep up our spirits up about challenging suitability decisions, and to realise that local authorities are very, very busy and they're not necessarily as well trained or resourced as they should be. So they will make often basic mistakes like they did in these two cases, which you would think that Charlotte was, so it's that nearly 20 years ago, but they're still making the same mistakes and they're still relying on Now Medical, which I personally, I mean, I just don't understand how they can do that, because I just think they're setting themselves up every time they use them. Because, and I'll just say this last passing thought, and it's not about Now Medical being a bunch of rascals or anything like that. That they're doing their job is a sort of flawed job, because what they're supposed to do, the council's medical advisor is supposed to advise people about medical issues. Forgive me if you guys know this, but I'll say it again. It's just about, if you want to know what sort of osteoarthritis is and you're a reviewing officer and you want to know what the effect of that is on X, Y, or Z activity, you should ask the medical advisor, could you tell me about this? What you don't do, but they all do this, is treat the medical advisor as a medical assessor, because they're not carrying out a proper assessment. And so all they do, and now I think Now Medical should refuse to do this, but obviously they wouldn't get asked to get paid for their work if they didn't, but they should say, well, I can't really comment on this person because I haven't examined them, but I can tell you that if somebody has post-traumatic stress disorder, they might be more sensitive to noise than somebody who doesn't. I mean, that's about as far as it goes, but you get into these ridiculous, it's like me talking about the people that live 5 doors down who I've never met and what they might be like. I mean, my opinion
And then
is not worth much.
And then if they were only doing that as well, like I didn't do casework for very long, but you get to know about conditions. Like if you're working with a caseload, and some local authorities have a caseload of over 100 people, right, you might not know how that PTSD affects that one individual specifically, but you know roughly how PTSD could affect that one individual. You know roughly what the medical conditions are. Like, I think there's something happening in the sector where we're almost trying to get loads of professionals being absolute experts in everything, and it's not needed. And we're like, and some train, I'm not saying don't train people, and like housing officers should be experts in housing law, for example, and they're not. But in terms of like medical stuff, you don't need to be some hugely trained person to Google arthritis and to look it up on the NHS website, or to look it up in a book, or to look up medication. I don't know, maybe that's just because how we did things, and we sort of researched conditions our clients had to make sure we understood what was going on. But yeah, I can't remember my initial point. Sorry.
Well, I think it's just what you were saying. Everybody has to pretend to be a really big expert on these things, but I think the problem for Now Medical is that they allow themselves to be used as assessing people, which I'd have thought. I was watching an old clip from Dragon's Den the other day, and there was some bloke that had a great idea for a business. He called it Car Doctor. And if your car breaks down, you can ring him up and he'll tell you what he thinks. But they said, well, if you haven't examined a car, what can you say? And he said, well, I can tell you to take it to a garage. And I said, you're not going to make a lot of money. But that's sort of all he can do, really, isn't he? He can't do much more. But on that rather confused note, I will leave it. And so would I see you guys on Thursday? Great. And thanks, Tiff, for your comments, and Casey for yours. And hopefully we'll do some more stuff like this. If there's anything else anyone would like me to talk about, do put comments on. You can just put comments on any show and I'll see them and take it from there. So I will end the show for now and see you everybody hopefully next Monday on my show, Thursday on Mike's show. Bye.